So good morning, everyone. Welcome back to our weekly webinar series. And today we thought we will have a recap on all the latest Supreme Court judgments, the position of law from the Apex Court, and the way forward from there. We have discussed many of these judgments in the past as well, but a recap will help us understand the entire CIRP liquidation law better in combined reading with all these judgments. So over to Anil sir, and let's take it forward.
Thank you, Ankit. So welcome to 39th episode of our weekly webinars. This time, the year 2022 has gone by. We congratulate all our participants, well-wishers. We wish them Happy New Year and wish that this coming 2023 and forward should be blessed for all of us. And we should actually continue our endeavor to spread knowledge and our experience. We also would like to share with you our happiness that AAA Insolvency Professionals LLP was the first IPE to be registered as insolvency professional, and it has also become the first IPE which has been appointed as the RP by the adjudicating authority, a Mumbai bench. So that's a great news for us. We feel happy about our achievements, and we also feel that it is all because of the blessings of our friends, our listeners. So thank you very much. We are very happy about all this landmark. Similarly, we all are having this recap on the landmark judgments of Hon'ble Supreme Court during 2022. Without wasting further time, I will just share my PPT with you. So Ankit, more or less it would be a kind of discussions, and after all the facts that we gave, I think you and me both would be discussing these judgments, the impact of these judgments. So these are the various topics. What we have done, we have categorized the Supreme Court orders in these subjects like financial and operational creditors, because the differences that we have seen, what is the difference between Section 9 application and Section 7 application, and that's focused on the Garba industries. Withdrawal of CIRP as a right of the corporate debtor, as a right of an applicant. Resolution plans, personal guarantors, moratorium, limitation, NCLT, not a money recovery forum. Commercial wisdom, CIRP cost, Noida as operational creditor, and insolvency professionals remuneration. These are various subjects that we have categorized all the judgments, and we have only taken the landmark judgments in the from this Honorable Supreme Court. We have because this particular subject is a little larger, we also would like to share the impact of these judgments according to our experience. Therefore, we propose to complete this subject in 2 webinars, one which is now, and the next would be on 14th. 14th is again on Makar Sankranti, so I think morning, Saturday morning, 11 o'clock would be suitable to all of us. So we also feel very happy when we see the participants joining the webinars, and that actually motivates us. And also we see when we upload our webinars, our discussions on YouTube, and when we see and go and check this views on our webinars, so we also feel happy that there are people, they they listen to us, they view our videos, and we've seen that mostly the students, they actually, anyone who is passing an examination for an insolvency professional, the bankers, see, there are, because the industry is very small. In fact, total, in case we would see in total India, there may not be more than 10,000 people who are having interest in insolvency and bankruptcy practice. So therefore, we are still very happy that out of those 10,000 total audience available in India, we still get a lot of response. The first subject that we are going to touch base is the financial and operational creditor, the difference, the landmark judgment with Vidarbha Industries Power Limited versus Axis Bank Limited. This was dated 12th of June 2022, and we will also touch base on the review petition which was filed. So in Vidarbha Industries Power Limited, the basic difference which has been drawn by Honorable Supreme Court is what is the difference between Section 7 and Section 9 applications. So in this particular case, this particular application to Supreme Court was filed by Vidarbha Industries Power Limited, the corporate debtor, and it's a power generation company, and it was regulated by State Electricity Regulatory Commission. The Axis Bank preferred an application because Axis Bank, I think there was a dues of about 700 crores, and the application was preferred by NCLT also, and NCLT admitted the application based on the debt disbursement and default. And since this was Section 7 application, so there was no question of any dispute to be seen by the adjudicating authority. So they saw the debt, they saw the disbursement and the default. So the application was admitted, and the applicant, Vidarbha Industries Power Limited, even further applied to, made an appeal before NCLAT, and that appeal was also dismissed. And they probably thought that when there are three, in fact, this was also discussed by the Supreme Court in the observations, that this is what is likely to be seen. Everyone sees this law, like in case there are A, B, C, D, E clauses, in case all are satisfied, then it is mandatory for the adjudicating authority to pass an order commencing CIRP. The facts in this case is like the Vidarbha Industries. In fact, they had an order from Appellate Tribunal for Electricity, and they actually the order was that the Vidarbha Industries is entitled to a sum of rupees 1,730 crores, and that particular order, the money was recoverable from Maharashtra Electricity Regulatory Commission. I think the dispute was based on the kind of power purchase agreement and the rates in the power purchase agreement and all those terms and conditions. So this was the order. Now, when this order was communicated to Maharashtra Electricity Regulatory Commission, rather than giving 1,730 crores, the MERC in fact filed an appeal before the Honorable Supreme Court challenging the order of APTEL, Appellate Tribunal for Electricity. And this appeal was pending before the bench. So there are two things pending before the Supreme Court. One, that the order entitling the Vidarbha Industries, where the Vidarbha Industries is entitled to 1,730 crores, and an appeal filed by MERC is pending before the Honorable Supreme Court. Now, while that is pending, and the Vidarbha Industries filed an appeal before Supreme Court that we are short of funds, we are a healthy company. In case we get this 1,730 crores, we would be able to meet our obligations. We would be able to pay all our debts, and we are very close to getting that we are very close to getting that landmark. That particular application is also pending before Supreme Court. So this was the basic issue, like whether a company's financial health is to be seen, whether it is to be seen, whether it is expedient to go for CIRP or there is a better solution available. So this was the basic issue before the Supreme Court. In fact, both NCLT and NCLAT proceeded on the premise that the applications under Section 7 has to be admitted. It is mandatory. That's what they thought. So this was the issue, like Section 7, subsection 5, clause A of the code is mandatory or a directory provision. Now, these are the kind of observations made by Honorable Supreme Court. It was saying that the NCLT is required to ascertain the existence of a default from the records of the information utility or any other evidence furnished by the financial creditor under Section 7, subsection 3 within 14 days. And CD, who is in red, should be resolved expeditiously. Following the timelines in the code, no extraneous matter should come in way. However, the viability and overall financial health of the corporate debtor are not extraneous matters. This was the observations by the Supreme Court. The Supreme Court also kind of mentioned the Section 7(5) subsection A, subclause A is mandatory or discretionary. So the observation reads like this: NCLT is required to ascertain the existence of a default from the records of the IU or any other evidence furnished by the financial creditor under Section 7 of the code, and the application has to be admitted in 14 days. Legislature has, in its wisdom, chosen to use the expression may in Section 7, subsection 5, clause A of the code when NCLT is satisfied that the default has occurred and the application of the financial creditor is complete and there is no disciplinary proceedings against the proposed IRP, it may admit the order. So the word is may, if the NCLT is satisfied that the default has occurred. Now, this particular scenario, if the default has occurred, now this was the only satisfaction which was required for NCLT to pass an order. So still, it was may, even after the default has occurred. The further observations of NCLT was when the NCLT, further observation of Supreme Court, because the Supreme Court tried to differentiate between Section 9, subsection 5 and Section 7, subsection 5. It says that Section 9, there is an operational creditor admits the same and communicable its decision to the CD, provided the conditions under A to E, sub clauses A to E are satisfied. NCLT must reject the application in the circumstances specified in section and clauses A to E. So legislature has in its wisdom used the words may in Section 7 of the code and in respect of the CIRP initiated by a financial creditor, but has used the expression shall in almost identical provisions of Section 9 of the code. It further said that the Section 9 applications are mandatory. An application of operational creditor is mandatory if there is no dispute. If there is an admitted debt, it is mandatory. However, for a financial creditor, it may not be mandatory. That's what final observation of the Honorable Supreme Court was. So, however, in case of application by financial creditor, the NCLT is to examine the expedience of the initiation of CIRP, taking into account all relevant facts and circumstances, including the overall financial health and viability of the corporate debtor. NCLT may, in its discretion, not admit the application of a financial creditor. So there are 2-3 things that is to be seen: expedience of initiation of CIRP, overall financial health and viability of the corporate debtor. These are the things which are supposed to be seen by the adjudicating authority before any order under Section 7 is admitted. See, going forward, the legislature has consciously differentiated between financial creditors and operational creditors, as there is an innate difference between financial creditors in the business of investment and financial. See, the Supreme Court is of the opinion that the financial creditors are in the business of investment and financing, whereas the operational creditors are in the business of supply of goods and services. Now, the impact of non-payment the impact of non-payment of admitted dues could be far more serious on an operational creditor than a financial creditor. So finally what was held? It was held by Supreme Court that the NCLT and NCLAT fell in error in holding that once it is decided that the debt has existed, the corporate debtor was in default payment of debt, and there is no option with the NCLT but to admit. This is a error by the NCLT and NCLAT. The courts below have simply brushed aside the case of the appellant that an amount of rupees 1,730 crore, which was realizable in terms of the order passed by the appellant in favor of the appellant, with a cursory observation that disputes, if any, between the appellant and the recipient of electricity or between the appellant and the Electricity Regulatory Commission were inconsequential. For giving a recall, the claim of Axis Bank was about 500 crore, more than 500 crore, whereas the amount which was supposed to be recovered from APTEL, which was supposed to be recovered from MERC, that was 1,730 crore, much more than the amount of default. The held portion continues, so it says further, the existence of financial debt and default in payment thereof only gives a financial creditor a right to apply. That is only a right to apply, and that is not giving a kind of directions to adjudicating authority for passing an order. The objective of the Insolvency and Bankruptcy Code is not to penalize solvent companies. Temporary defaulting in repayment of its financial debt by initiation of CIRP is not, which is something which is the objective of the IBC. Section 7, subsection 5, clause A of the code. The discretion, it says that the confer discretionary powers on the NCLT to admit an application of a financial creditor for initiation of the CIRP. NCLT is required to apply its mind to relevant factors, including the feasibility of the initiation of CIRP. Feasibility is one section. In the present case, the impact of MERC's pending appeal, order of APTEL, and overall financial health and viability of the corporate debtor under its existing management, that should have been seen. Therefore, the appeal is allowed. It was directed that the CIRP should be considered as quashed. Now, in this case, when we see what exactly have started happening, although in the review petition, the review petition was filed by Axis Bank. Axis Bank thought that the judgment of the Supreme Court is too aggressive. So the Axis Bank filed a review petition before the Honorable Supreme Court, and the judgment also came on 22nd of September 22. In that judgment, although the same things were repeated, all the facts were repeated, that this was a 600 megawatt coal-fired thermal plant, and all these facts were repeated, and finally everyone submitted their submissions also, and again the same submissions were repeated. Now, in this case, finally, in the review petition, finally the Supreme Court said and repeated that Section 7, subsection 5, clause A of IBC provides that where adjudicating authority is satisfied that a default was occurred and the application under Section 7 of the IBC is complete and there is no disciplinary proceeding against the proposed RP, it may by order admit such application. It is again repeating the word may. Then the Supreme Court said in its review petition order, it is well settled that judgments and observations in judgments are not to be read as provisions of statute. So they were saying that not that you should actually consider this as a law. You should not consider this as a law. Then again, Supreme Court said that the judicial utterances and or pronouncements are in the setting of the facts of a particular case. To interpret words and provisions of the statute, it may become necessary for the judges to re-embark upon lengthy discussions. The words of judges interpreting statutes are not to be interpreted as statute. The judges are only for interpretation. The judges are not for making the law. So whatever words they say, that should be considered as their interpretation and not as the law. Further, the Supreme Court said that the applicability of this judgment would depend upon the facts and circumstances of each case. And for the decision to be binding for any other case or any other court shall have to be satisfied that the based on the facts of the decision of the Supreme Court in Vidarbha shall be applicable. So what was the facts in this case? The claim was more than 500 crore, about between 5 and 600 crore. The amount which was due to the company, which was supposed to be received by the company, was 1,730 crore. Both the matters were pending before Honorable Supreme Court. The Supreme Court could have decided the other matter. First, 1,730 crore could have gone to the company, and the company could have come out of the stress or default. So these kind of facts should be there. The interpretation of Section 7 by the Supreme Court by itself cannot be looked at as a provision under the code. So there are no grounds for review. That's what final order. No, what we are trying to say, Ankit, with this, we have seen that in some other cases also, the lawyers have started arguing on behalf of the corporate debtor that our restructuring proposal is pending. Our restructuring proposal is a better solution. That's a better solution for resolving the stress of the company. That is expedient. The overall financial health of the company is very good. The company has some arbitration cases pending, and the arbitration judgments are reaching their finality. So therefore, the company is having a very, very good fund flow in the near future. This particular default is temporary. So the temporary defaults may not be punished.
But there's only a timing gap between the current dues and the dues that are supposed to be received in the future. So in that way, as many companies will escape. But then I think the review judgment is something that should be acknowledged, and that should be brought forward to the judges. But still, the similar principle of law that if a matter is pending in the same court, then you can say that no, the insolvency should not happen, or in case somebody says I have still money due from this company. Again, let's see how it frames up. But this judgment was definitely something that unsettled the whole idea that the moment you have a financial debt outstanding, then the NCLT is supposed to simply process the company and initiate the CIRP. So the 14 days that is anyways a long period of 1 or 2 years will maybe become longer with this judgment for almost all cases.
So this is what was the judgment. This is what was the review. See, all said and done, the new Pandora box has actually been opened. The new kind of arguments have been opened. The lawyers definitely will drag based on these observations of the Supreme Court. They will drag all the cases. As I said, they will refer the restructuring proposal. They would refer the one-time settlement proposal. They will refer the overall healthy situation. They will refer that the company is temporarily stuck up somewhere. They will
see,
yes.
The biggest problem today is that in case somebody files a CIRP application against a company, the company and its promoters, the management start planning for that insolvency immediately thereon. In case you give them 14 days versus in case you give them 1 year or 2 years to fight in the court and debate it, they use the same time to scavenge whatever assets they are left with. And that would then be an ultimate demise of IBC as a process, because banks, creditors will not get anything because of the delay in the admittance itself. So the whole idea is that you do a default 14 days, within 14 days you get into the process. That culture is what was intended to be established, but then this is not establishing it.
So in the colloquium where all the NCLT members and NCLAT members were present along with the IBBI and MCA, I also had the opportunity to attend that colloquium for 1.5 days. So we have seen that the lenders were not happy. In lenders in this country, because this particular colloquium was also having the presence of many executive directors of leading banks. They were not happy about this judgment, and the only thing that they were saying that this will only delay the admittance of the Section 7 applications, and that actually would be, as you rightly said, scavenging opportunity for the promoters. I think we can move to the next judgment, which is Kotak Mahindra Bank Limited versus Balakrishna and others. This judgment was on 30th of May 2022. And this judgment was like it was a case where the a real estate company, uh, it was the real estate company is the corporate debtor. Uh, the Kotak Mahindra Bank is the appellant in this case, and also it was an assignee of a certain loans in respect of Prasad Properties and Investment Private Limited. So there was a compromise settlement, and in 2006 entered between the appellant and the corporate debtor. The DRT issued a recovery certificate dated June 2017, October 2017 in favor of the appellant. So scenario is that this company, Prasad Properties and Investment Private Limited, they had a kind of the default was much older. Kotak Mahindra Bank, before IBC came in light, before the IBC was promulgated in this country, they had gone to DRT and they were able to take a recovery certificates in June and October 17. So when this June and October 17, they saw that the recovery certificates are there, and in 2018, Kotak Mahindra Bank filed an application under Section 7, and it was admitted in September 2019. Now, the basic issue in this case is the admission order was challenged before NCLAT, and the NCLAT, in fact, passed an order on 24th of November 20, setting aside the admission order by holding that the application under Section 7 is time barred, and that the issuance of a recovery certificate would not give rise to a fresh period of limitation. So this judgment, Kotak Mahindra Bank versus Bala Subramaniam, is the judgment on the limitation part. Now, the issue is whether the recovery certificate is a financial debt. Second issue is whether the Section 19, subsection 22 and Section 19, subsection 22, capital A of the Recovery of Debt and Bankruptcy Act restrict CIRP based on recovery certificate or not. The submissions by appellant means Kotak Bank. The Kotak Bank said that the Section 7 application was filed by the applicant within 3 years from the date on which the recovery certificates were issued. Basically, Kotak Bank is trying to say that the recovery certificate is a kind of fresh start of the limitation period. Fresh start of the limitation period. That's what the Kotak Bank is trying to say in the appellant. In view of the decisions in the Dena Bank, it is settled a fresh period of limitation is available from the date of recovery of the certificate. The Dena Bank judgment again is from Supreme Court. Now the respondent means the company, the real estate company says that the cause of action, that the default that we incurred, that is merged into the DRT's order, issuing the recovery certificates. Now the Kotak Mahindra Bank should go and recover from the implementation of the recovery certificate, and they cannot start another litigation at this point because that particular default, for the same default, they have already got one order in their hand. In view of Section 19 of Section 22A of the RDB Act, which states that the recovery certificate shall be deemed to be a decree for the purpose of initiation of inter alia winding up proceedings under the Companies Act 2013. In fact, this particular argument, which was given by the respondent, in fact, helped the applicant, because when the court saw that Section 1922A of the RDB Act itself says that in case there is a recovery certificate, that actually would be a very good, good evidence document for initiating winding up proceedings under the Companies Act. So when the winding up proceedings can be started based on a recovery certificate, then why can't a resolution proceedings can be started based on the recovery certificates, which actually will end up into liquidation in case there is no resolution found. So this argument, this Section 1922A, in fact, helped the Kotak Bank to get this order. No, the company again said that the judgment in the Dena Bank is per in curiam and then rendered without considering the correct position of the law, as it does not correctly consider Section 1922-22A of the RDB Act, as well as Section 5, 7, 5, 8, and all of the IBC Act. And then they also said that the judgment in Dena Bank is also contrary to the judgments of Supreme Court in the case of Jignesh Shah and others. Whereas the initiation of CIRP was held to be barred by limitation despite pending recovery proceedings. Now, the Supreme Court finally found that the recovery certificate is a financial debt within the meaning of Section 5, subsection 8 of IBC. An application under Section 7 of IBC may be filed in respect of the default. The default is defined under Section 3, subsection 12 of IBC to mean non-payment of debt. Section 3, subsection 11 of the IBC defines debt as a liability in respect of a claim, and Section 3, subsection 6 of the IBC defines the term claimed to mean a right to payment, whether or not such right has been reduced to judgment. Therefore, if the submission on behalf of the corporate debtor is accepted, it would mean that the claim is excluded from being a financial debt, even if reduced to judgment, by way of a recovery certificate. So in case the Supreme Court thought in case we say no, then the definition of claim would also be violated. And the debt is also based on the definition of claim. So that means that in case a person has a recovery certificate, it still continues to be a debt. The Supreme Court further says that the list of arrangements that would qualify to be a financial debt, as mentioned in Section 5, subsection 8 of the IBC, is not exhaustive. This is also a very good observation that there can be any other kind of financial debt which is not even mentioned in Section 5, subsection 8. And it could not have been the intent of the legislative to exclude a liability for a claim that is due and payable in terms of a recovery certificate. Because see, it cannot be like if a person has a recovery certificate, he cannot he cannot be debarred from taking the help of IBC to find a solution. Therefore, any person holding such certificate is well within the scope of financial creditor. So it will become a financial creditor. It is a financial debt, that's final holding. Now, the further Supreme Court said that the judgment rendered in the case of Dena Bank is correct in law, because they were saying that the Dena Bank judgment is incorrect. That was the argument from the appellant. It says that the Dena Bank judgment only operates to prohibit a decree holder from executing the decree against the corporate debtor undergoing CIRP. So that is a question of Section 14 moratorium. So that's what the Dena Bank only said, that a decree holder cannot pursue and recover money because of the moratorium. And finally, the Supreme Court also said that the Jignesh Shah judgment of Supreme Court observed that the question as to whether a recovery certificate would give rise to a fresh period of limitation was not under consideration in either of the decisions. So that was not the decision. Finally, the decision was based on Section 19, subsection 22 and 22A of the RDB Act. Do not restrict initiation of CIRP based on a recovery certificate, when it was basically saying that this section allows the winding up proceeding, then it also allows the initiation of CIR. So this is the, so basically there are 2-3 things. On a recovery certificate, fresh period of limitation starts. Fresh period of 3 years starts. A recovery certificate is also a financial debt. The financial debt, it's a financial creditor. And it has never been discussed in Jignesh Shah or in Dena Bank that this kind of limitation period would exceed. And then the Section 19, subsection 2 of the Recovery of Debt and Bankruptcy Act is not restricting someone to only go and start the winding up processes. The winding up has now been taken over by the IBC, so that's what it is. So Ankit, for you.
So I think, yes, I think the good judgment holding on that this the whole idea of a recovery certificate, not that the bank having a recovery certificate will not be able to use it, has been finished here. Now the question here that I think one clarity is that in case there is a recovery certificate which is available with an OC for the dues that he has or the OC has against the CD, that will still hold as OC dues, right? Or will that also convert into a financial
No, I think that
creditor?
was another judgment that
Yeah,
the
so I think
any
combined reading of that judgment will then give an idea that recovery certificate or having a litigation or a favorable litigation in your hand will not change the nature of dues that one has, right? If you're an
absolutely, Ankit,
if
you
you're an
actually have
FC, you will.
hmm,
Yeah, so
you have
that's
touched
one
a very, very basic
clarification.
question.
That's one
Yes,
clarification is required here, but that because this recovery certificate was given to a bank for financial dues, it will remain FC due. Otherwise, it will remain an OC due, depending on the nature of the original transaction that had occurred.
absolutely clear. Absolutely. I think this is important that you brought this point because nobody should consider that the recovery certificate will make your debt as a financial debt.
Yes.
The recovery certificate will only make your debt as a payable amount, and it's a kind of
And also
admitted.
with respect to the limitation, if there is any proceeding which is ongoing for any recovery of any debt, even if the recovery certificate would not have been issued, the litigation is live, and therefore limitation period will anyways not come in. So a bank can anyways initiate CIRP process even without a recovery certificate when the proceedings are ongoing in the under the RDB Act.
So, Ankit, we can move on to the next judgment,
Yes.
which is regarding withdrawal of CIRP, as it is said that the withdrawal is the right of the applicant. He has all the rights to withdraw. However, in this case, which is Ashok G. Rajani versus Beacon Trustship Limited, 22nd of September 2022, this judgment, in fact, the Supreme Court has used its power in Article 142 and has allowed the withdrawal without an application from the applicant. Without an application from the applicant, this particular judgment is slightly different. Settlement under Section 12A of the IBC is pending before the NCLT. It is pending. However, the corporate debtor went to NCLT against the order initiating the CIRP. NCLT stayed the formation of Committee of Creditors but declined to exercise its power under Rule 11 of NCLT rules to take on record the settlement and dispose of the matter. Now, the Supreme Court says the NCLT stayed the formation of the Committee of Creditors, but they did not use the powers to take on record the settlement and dispose the matter and consider the CIRP as withdrawn. Now, NCLT permitted the IRP to issue publication and hand over all assets and proceeds with the CIRP, even though the matter had been settled between the parties. This is also one of the facts that the NCLT said that the IRP to continue. Being dissatisfied by the order of NCLAT, the appellant preferred a civil appeal before Honorable Supreme Court. And the issue before the Honorable Supreme Court was that is there any bar on withdrawal by applicant of an application under Section 7 of the IBC before the constitution of the COC. So there is no bar as such on the applicant, but in this case, the decision was slightly different. Now, Section 12A of the IBC enables NCLT to allow withdrawal of an application under Section 7, 9, or 10 on an application made by the applicant with the approval of 90% of the voting share of the COC. And in case it is before the constitution of COC, then it is only the applicant and no COC approval is required. Section 12A clearly permits withdrawal of an application under Section 7 of the IBC that has been admitted on an application made by the applicant. Applicant is the person who applied for the original CIRP, commencement of the CIRP, means the operational creditor or the financial creditor. The question of approval of the COC by the requisite percentage of vote can only arise after the COC is constituted. In this particular case, the COC was not constituted. Therefore, that 90% of the voting power requirement is not applicable. Before the COC is constituted, there is no bar to withdraw the application of an application admitted under Section 7. So the Supreme Court is saying also in this case that there is no bar. Now, the observation in the Supreme Court says that as per the statement of objects and reasons, the objects in the IBC maximization of the value of the assets of such person to promote entrepreneurship, availability of credit and balance of interest of all stakeholders, including alteration in the order of priority of payment of the government dues. This was the objectives. A reading of the statement of objects and reasons with the statutory rules 11 of the NCLT rules enables NCLT to pass orders for the ends of justice, including order permitting an applicant for CIRP to withdraw its application and to enable a corporate body to carry on business with ease, free of any impediment. In the present case, considering the investment made by the corporate debtor and the number of people dependent on the corporate debtor for their survival and livelihood, there is no reason why the applicant for the CIRP should not be allowed to withdraw its application once its disputes have been settled. The settlement cannot be stifled before the constitution of the COC in anticipation of claim against the corporate debtor from third parties. The withdrawal of an application for CIRP, the applicant would not prevent any other financial creditor from taking recourse. See, sometimes the lawyers also argue, Your Honor, in case you would allow this application to be withdrawn, there are many other defaults of this company. There are many other applications pending. So it is better that you let this company go through this CIRP process and let this be a complete check on the solvency of the company. However, the Supreme Court says that by just withdrawing one application, the other creditors are not losing their right. They will still have their rights to initiate CIRP against this company in case their dues are still under default. Now, the application for settlement under Section 12A of the IBC is pending before NCLT. The NCLT has stayed the constitution of COC. The order impugned is only an interim order which does not call for interference in an appeal under Section 62 of the IBC. There is no question of law which requires determination by this court. The appeal is accordingly dismissed. NCLT is directed to take up the settlement application and decide the same in the light of the observations made above. So, what exactly the outcome? The outcome is that NCLAT should have disposed of this application. NCLAT should have allowed the withdrawal, or the NCLT should not have continued the process because the appellant has filed the application. They have settled their disputes, so they have a right to let it be withdrawn. So, Ankit, any thought on this judgment? I think this is only a kind of clarification of the existing law. There is nothing new that applicant has a right.
There was some ongoing discussion which started happening, and I think there were a few forums where this was talked about by people in the audience as well, if I remember correctly, in the event hosted by AAAPI, and it was asked to the NCLT judges that you allow withdrawal of an application on the instance of any settlement, but at that point you're not looking into the solvency or insolvency of the company, looking at other applications which are pending against the same company and so on. So I think this is a rather a thumbs up from the Supreme Court that what the NCLT and NCLAT is doing in letting people withdraw their application on settlement of their dues is the correct methodology. So I think yes, that's confirmation of what has already been going on and what is the practice in the courts, nothing different.
Going forward, now we have this case Amit Katyal versus Meera Ahuja. Again, a civil appeal. The judgment came on 3rd of March 2022, and this was also an application filed by the promoter, majority shareholder of the company, aggrieved by the order of NCLT confirming the admission of Section 7 petition by the adjudicating authority. It was a housing project which actually remained incomplete for about 8 years. 3 home buyers filed a Section 7 application. So the original application was filed for an amount of around 7 crores due to inordinate delay in the completion of the project and the failure to hand over. NCLT admitted said application on appeal. NCLT also upheld the order of the adjudicating authority and initiated CIRP. Now, this corporate debtor filed appeal before Honorable Supreme Court, whereby the Supreme Court stayed the order of commencement of CIRP, for which the CD was directed to deposit 2.75 crore with 6% interest. So this order for commencement of CIRP was stayed by Supreme Court, while the NCLAT also upheld and NCLT passed the order. So the Supreme Court stayed it. See, this was the matter was getting adjourned from time to time, and in the meantime, the real estate, the promoter, the company, they trying to settle with the home buyers. They entered into a settlement agreement while this time was taking, while this matter was pending before Honorable Supreme Court. They, in fact, used that particular time and settled between the home buyers. So they, in fact, decided that they will complete the project in 1 year, and they will hand over the possession to at least more than 50% people in 1 year. And also they agreed to pay an interest of about 3.36 crores on the delay. And however, when the appellant approached the Supreme Court under Article 142 instead of Section 12A of the Code to accept the settlement and withdraw the CIRP. Now, the company says that I am settling with the home buyers. NCLAT has already rejected their arrangement or settlement. Now, the Supreme Court, in this manner, the Supreme Court says that relying on its judgment in Swiss Ribbon Private Limited and others, the Union of India, the Supreme Court held that after the COC has been constituted, a party may approach NCLT directly, and the NCLT may allow or disallow an application for withdrawal or settlement. Since 70% of the COC home buyers were in favor of the settlement and the matter have been stayed shortly after the constitution of the COC, no proceedings has occurred before the COC. So 4 people filing an application, or three home buyers filing an application, and the promoter finally objecting to it, and finally he settled with 70% of the home buyers. So in this case, the 70% of the home buyers may have reached out to Supreme Court that we do not want CIRP because the promoter has settled with us. So it is a suitable case to exercise powers under Article 142 of the Constitution of India, because the settlement reached between the home buyers and appellant and CD shall be in the greater interest of the home buyers, as out of 128 home buyers, 82 home buyers are likely to get possession within a period of 1 year, for which reason the original applicant was not required to approach the NCLT by moving an application under Section 12A of the IBC. So in this particular case, the original applicants, they were not required to move an application. The Supreme Court did it, means the withdrawal was made effective under Section 12A by Supreme Court, and the CIRP was quashed. However, the Supreme Court also kind of gave directions to the builder, and they were directed to abide by the settlement plan, and the separate undertakings were included that they will complete the entire project within 1 year from 1st March 2022, and after the possession to the respective home buyer to complete the entire project, including all the apartments, common areas, amenities, etc., as specified in the builder-buyer arrangement or agreement agreement of sale, to be filled within a period of 1 week from the date. So this was the kind of directions where the Supreme Court found that if the 70% of the creditors are saying that they are okay, they trust the builder, and the builder has given us a settlement which is a better settlement, So that kind of arrangement is also possible. So therefore, the Supreme Court quashed the commencement of CIRP. Yes, Ankit.
So, like, it's once the COC is constituted, the withdrawal can happen with 90% voting of the creditors. So, Supreme Court simply used its powers under the Constitution to change that 90 to 70. But the next question that I'm wondering about is that in case of home buyer voting, in case more than 50% vote in favor of a resolution, the voting is deemed to be 100% towards that resolution. So how come 70% home buyers were not able to pass the resolution to withdraw the CIRP?
No, I believe the committee is not constituted so far, because had the committee been constituted, then there would have been some reference to the other creditors like the banks or other people.
Reference to the COC, so that must
Ah.
have been just
Mhm.
like a reference to the creditors in effect, because the order was referring to the COC. But then this must be then withdrawal before the first COC commencement or initiation of CIRP, maybe.
So I think we can move to another judgment. We can only take up, I think, one, because already we have 8 minutes left in an hour. So this is a plan on a resolution plan, Maitreya Doshi versus Anand Rathi Global Finance Limited, and this judgment is dated 22nd of September 2022. I believe this judgment belongs to Premier Automobile, because I still remember the Mr. Doshi was the promoter of this company, Premier Limited, and earlier it was Premier Automobile. So the appellant is a director of Doshi Holdings, and they took a loan from Anand Rathi Global Finance Limited. The loan was disbursed to Premier Limited. Loan was disbursed to Premier Limited, and the Doshi Holding pledged the shares of Premier Limited before the Anand Rathi. So the loan was disbursed to Premier Limited. It was not disbursed to Doshi Holding. The documents were signed by Premier Limited as well as Doshi Holding. In the documents, both were considered as co-borrower. The Doshi Holdings also pledged their shares in Premier Limited to Anand Rathi. So this is a kind of where in fact, one loan, two borrower, Premier Limited has got the disbursement, Doshi Holding has not got any disbursement, and the security which is owned by Doshi Holding is the security interest of Anand Rathi Global. Now, when this default took place, the Anand Rathi initiated insolvency of both the companies, and the Doshi Holding, they in fact preferred an appeal that once the insolvency of one has already been started, and from the same set of documents, from the same loan, how can the other company's insolvency also be started? It was also argued that the disbursement was not made to Doshi Holding. Disbursement was only made to Premier Limited. It was also argued that the Doshi Holding is made as a co-borrower is not really correct. Doshi Holding cannot be a co-borrower because the money has not been disbursed. So therefore, this present appeal, where the issue before the Honorable Supreme Court was, if there are two borrowers or if two corporate bodies fall within the ambit of corporate debtor, can proceedings under Section 7 of IBC be initiated against both? So this was the case which was decided positively by Honorable Supreme Court. Now, the agreement contemplated in two distinct transactions, this was the appellant what was saying. The appellant was saying agreements were only one: creation of the pledge by the holding company, financial creditor granted loan to Premier, and no amount under the agreement was disbursed to Doshi Holding. The loan was never utilized by Doshi Holding. That the reference of both Premier and Doshi Holding as borrower in the agreement was only done for the sake of convenience. The fact remains that the Premier was the borrower and the Doshi Holding the pledger. They were not even saying the grantor. They were only saying that it is a pledger. and they both represent separate entities. Since no disbursement was made to Doshi, there is no obligation on the Doshi holding to make any repayment to financial creditor, and no financial debt was owed by Doshi holding to financial creditor. Further, NCLT and NCLT erred in finding that the Doshi Holdings was a borrower by misconstruing the expression financial debt, and they were trying to distinguishing between the contract of indemnity, and pledge. So they wanted that we should be considered as a pledger. Doshi Holding also wanted that they should not even be considered as a grantor. They only wanted that they should be considered as a pledger. They wanted that we are not the co-borrower, we are not the grantor, we don't have the indemnity contract, we are only a pledger. So they wanted to say that the pledger is not a borrower, pledger is not a financial creditor, because the pledging is not even a guarantee. That's what is their argument. So they did not and did not and cannot amount to a guarantee and or indemnity under the definition of financial debt. Further, relying on the Phoenix ARC Private Limited versus Ketul by Ramu by Patel, it was contended that the pledger of shares of a CD can be best equated with a secured creditor and not a financial creditor. This was their argument. They further argued that when one bench of NCLT admitted the petition for initiation of CIRP, in fact, that bench mentioned when the Premier Limited was ordered for CIRP, it was mentioned for the same set of loan arising under the same loan augment, the same debt claim against Doshi would not be permissible. That was held by one of the judge in one of the order. But because both the companies had different registered offices, maybe different registered office, but then it was before the different bench. So the bench for Premier Limited said that for the same debt, action against Doshi is not permissible. When it went to the other bench, which was handling the application for CIRP of Doshi Holding, that particular bench says the Doshi Holding is admitted for CIRP. The respondents in this case, respondents means the bank, Doshi Holding was a party to the agreement in its dual capacity as a co-borrower, as a pledger. Further, the appellant, who was director in both Premier as well as Doshi Holding, had signed the documents on behalf of Doshi as co-borrower. Doshi Holding had acknowledged receipt of monies disbursed under the agreement by executing loan receipts and has also issued promissory notes promising repayment of the loan to the financial creditor. Also, after Premier defaulted in payment of loan, demand notice was issued to Doshi Holding. So the bank made Doshi Holding as a grantor, as a co-borrower, gave a notice to them, and it was also acknowledged by them. So it was emphasized that the sine qua non for an entity to be considered as a corporate debtor is that such person entity should owe a debt to any person and not that a disbursal has to be made. So this was the argument from the bank that there has to be a debt owed by the company, and it is not really important that the disbursement also should have been made to him. There are many kinds of debt where there is no disbursement made, but still those are debts. Doshi Holding satisfies all this. This is the Honorable Supreme Court finally suggested that it appears that Doshi Holding was a party to the agreement in the dual capacity of the borrower and the pledger of the share. NCLT's finding that Doshi Holding is also a borrower under the agreement is a plausible interpretation and shall not be interfered within the appeal. The court relied on its earlier judgment in the case of Lalit Kumar Jain versus Union of India to rule that the approval of a resolution plan in respect of one borrower cannot discharge a co-borrower. However, the Supreme Court said that in case any money would be realized that would be reduced from the other, there is no possibility that the both can be recovered. I think the next session that we'll start from the popular rainbow paper judgment. So we end up with our time. We'll take up some of the questions in case there are, Ankit, and also some of your observations that you can add upon this last judgment where the CIRP has been commenced on pledger as well as the borrower, and also the pledger was considered to be a borrower. it was
So I think
considered to be, yeah.
so it's in line with the series of judgments where the welcome step that is happening is that the banks now have the freedom to proceed with all the options and all the options that they have. The options typically would include the primary borrower, then the options would be against the provider of the collateral, who also normally provides a guarantee, maybe a corporate, maybe an individual. And the good thing that has happened now is that the banks, I believe, as compared to earlier, are acting more promptly against the guarantors or the pledgers in this case. And these series of judgments, which says that the banks are totally rightful to act against the pledgees, is good. And I think it's a welcome step, and that would certainly bring more recovery to the banks for their stressed assets. And I believe earlier, before insolvency, the options with the banks were limited to maybe fighting these guarantors in the DRT or using SARFAESI Act. But this IBC route against guarantors would definitely allow more settlements to happen wherever the guarantors are having a high net worth or having still, some asset base with them.
Good,
We
Ankit. I
have a
think
few.
let us see the questions if
We
there
have
are
four
any.
questions. So question number one: suppose if an OC filed an application against Vidarbha on the same day as Axis Bank, then would it have been admitted? How the SC's viewpoint will hold? So I think the question is
Very valid
that,
question.
yeah. So if OC had filed an application against Vidarbha rather than an FC, then the Supreme Court's ruling, as we have read it today, says that with respect to an OC, it is recommended, it is not mandatory, or it is discretionary rather.
No, in the case of OC, it is the mandatory. If there is no dispute, it is mandatory. But in the case of a financial
opposite,
debt,
my bad. Yeah.
yeah.
So my bad. So in an OC's case, then the Supreme Court would have said the same thing or different thing. That's the question. So I
I
think
think
the matter.
it's like it was also said by Supreme Court that in case of an operational creditor, if there is a default of operational creditor, it actually has the ramifications which was more higher than the financial debt, because the financial, the institutional, that the lenders, the financial institutions, they have the habit of disbursement and default, and they can also have some kind of restructuring. However, an operational creditor, if a company is not able to make payment to an operational creditor, that actually shows the insolvency of a company. So that is mandatory.
So another question from Sanjeev Goyal ji. He says, to what extent the pledger is liable, either to the entire debt or to the extent of the security provided? Also, whether the CIRP can be initiated against the pledger while the CIRP is still under process against the borrower. So yes, it can be
Yes, I think
initiated
yes.
simultaneously, number one. Number two, with respect to the pledger being liable, to what extent, the myth that many people believe in when they're taking loans is that we are providing a collateral and then we are providing a guarantee towards the same collateral or for the same collateral for the same amount. But it is actually, double the guarantee. The collateral is also guaranteed, and that action can also be taken, and the personal guarantee can also be invoked.
It all depends upon the agreement. There are agreements that I have seen where a property or is mortgaged or and some securities are pledged. Then the pledger can stipulate in the agreement that my obligation is only to the extent of the value of this property or the value of the securities. In case there is nothing like this, then he would be considered as overall guarantor to the loan. That's what it is like.
So I believe that's about it. So yeah, I think questions are resolved. So other questions were repetitions. So thank you everyone, and looking forward to see you next week with the second part of this series, and we'll take it forward.
Thank you very much. And the kind of response today, the numbers of our viewers today increasing a lot. Thank you very much. I think this decision of shifting it from Sunday to Saturday is really working. Thank you for the suggestions that you had given, and we will work as we've been working in the past for analyzing any new law, any new judgment, and any new environment. We are also, as I said, that we are also starting because our law firm is focused on IBC, SURFACE, DRT matters, and the recovery of debt. So we are also starting now the webinars on recovery of debt. So will come up very soon. Thank you very much. Thank you.
Thank you, everyone.